That's an interesting case. It sounds like the Harris County bail system has undergone some significant changes recently. This general order bond rule seems to have a big impact on how misdemeanor cases are handled. It's clear there's a focus on reforming the bail system to make it more equitable, but it also raises questions about public safety and ensuring defendants appear in court. It'll be interesting to see how Judge Fletcher handles Keelan Hawkins' case and what the outcome means for her and potentially the bail system itself.
Good morning, Ms. Hawkins. Ma'am, you're charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, ma'am.
Yes, Judge. On March 6, 2025, at approximately 10:29 p.m., the officer observed a vehicle driving with expired registration as of March 2021. A traffic stop was initiated. However, the vehicle continued to travel down the feeder road until it turned and pulled onto the wrong side of a two-way road and parked facing northbound in the southbound side of the roadway. The officer made contact with the defendant, the driver, and sole occupant of the vehicle, and observed the defendant to have bloodshot eyes, droopy eyelids, and a strong odor of an alcoholic beverage. The defendant admitted to drinking 1.5 alcoholic beverages, and the defendant stated she was buzzed but not drunk. An inventory search of the vehicle was conducted, and the officer found a large plastic cup that was 1/4 full of alcoholic beverage that smelled of tequila in the center console cup holder. Standard field sobriety were conducted, HGN 6 out of 6, walk and turn 5 out of 8, one leg stand 3 out of 4. The defendant was read the DIC and refused to provide a specimen. A blood search warrant was signed and executed.
Are you telling me that she has alcohol in the car while she's driving?
It's just getting a cup of alcohol.
Ms. Hawkins, I'm going to find that there's sufficient probable cause to go forward with your case. I am now placing several conditions on your bond. If I find that you violate these conditions, I will revoke your bond, put you in jail. No more PR bonds, ma'am. You're not allowed to drive. I'm taking away your privilege to drive. You will be signing an affidavit with me today promising me you're not going to drive. I don't care what's going on in your life. If I find that you do, I can have a contempt hearing. You can be facing an additional 6 months in jail and a $500 fine. This is an affidavit that you're going to promise to me that you're not going to drive. Do you understand?
Yes, sir.
I'm also ordering you as a condition of your bond not to consume alcohol, illegal drugs, or unprescribed controlled medication. If I find that you're consuming alcohol or illegal drugs, likewise, I will revoke your bond, put you in jail, ma'am.
Judge, is that standard for driving?
She has alcohol in the car while she's driving. And so I would presume that it's elementary that you're not to have alcohol in the car while you're driving. It scares me, and I just don't want her driving for now.
Wow, that's a pretty clear rundown of the situation's decision. It sounds like he really prioritized community safety by going beyond the prosecution's request. The judge had the authority to impose those stricter conditions, even if they weren't legally required for a first-time offender. It just shows how much discretion judges have in these kinds of situations, especially when it comes to public safety. It's a good reminder that the law sets minimum requirements, but judges can impose stricter conditions if they deem them necessary.
Understood.
We can approach at a later date, but I'm
concerned because for her employment, she can't get in from work, and we can't get an occupational license for something like this. It's a condition of the court. I don't think we have any opposition to putting a lock in the vehicle so that she's not able to drink and then drive. But it just seems like no driving at all seems a bit harsh for a first offense. We don't even know what the blood is at this point.
Get it? But she has alcohol allegedly in the car while she's driving. One would presume that that's a humongous no-no, you know? And I want her to appreciate the privilege it is to drive. It's not a right. It's not a right. It's an absolute privilege.
Judge, if I may, what would be the conditions under which she's able to come back and get permission from the court? At what time frame?
I need to know that she understands and appreciates the privilege, you know? Be proactive. It's not forever, Aaron, you know, but I want her to understand that it's a privilege, it's not a right, and it's something that people should take very seriously. I don't want you to talk here now in front of him. You know, you guys at a later date can come back. I'm always all ears. Like, it's not absolute.
For Greg's purposes, since he's going to be the one representing her, well, what is a later date? I mean, is there something we can do? Because, you know, if it's something that you'd like her to do while on bond to make sure that she's, you know, addressing the issue. I mean,
be creative, be proactive. I want to know that she appreciates it. and I'm all ears, but it's something that I've seen more and more, where there's alcohol in the car, and I would presume that you would know, especially at this age that.
Well, to be fair, Judge, the allegation is that she violated the law. The presumption is that you would know not to violate the law, period. I personally don't think that the fact that there is possible alcohol in the car, I don't think it's been tested, but it just seems like no driving at all seems like a harsh penalty for someone who's never been arrested before, no criminal history. These are allegations. There's a blood draw pending. According to the dim summary, she had 1.5 drinks. It's certainly possible her alcohol level comes back below the legal limit.
The lawyer for Hawkins asked the judge to allow her to drive for work, but the judge denied that request for now. It's important to know that driving restrictions imposed on bond are different from Texas's driver's license rules. Since Hawkins's blood test results weren't in yet, her license hadn't been suspended by the state, but judges still have the authority to prevent driving for public safety. If her blood alcohol level comes back above the limit, her license would be suspended anyway, requiring her to apply for a special occupational license for limited driving. So her ability to drive was risky due to both the judge's decision and the potential blood test results.
And if that takes 90 days to get those lab results and come back and get this taken care of, she's not driving for 90 days.
I'm not saying that long, Aaron. I just want some kind of proactivity that I know that she appreciates. Come back and,
And just
Hey,
for Craig's purposes, so I can convey this debate. What's proactivity to the court?
just be creative.
Okay.
Be creative. And, several weeks, come back and we can talk. But it's a privilege. It's not a right. And it's something that we take very seriously. Every single day, someone dies from a DWI in our county. Every single day. And we need to ensure that it's taken seriously. I'm not asking for much. And once we know that there's appreciation, then let's talk again.
I'm not sure I understand. Could you repeat the information again?
How's it going?
Oh, good. Thank you.
How has it been? Not tough, isn't it?
Yeah.
Sucks. Living in a city as big as Houston without the ability to drive blows. And the only thing that I'm trying to get to you is to understand that it's a privilege. It's not a right. Every single day on our streets, someone's dying from some kind of alcohol-related collision. That's what we're trying to impart to you here, to take it seriously. It's not a joke, and the last thing I want is for something like that to happen here. You understand? All right. I'll take off the restriction. Okay. What does she have now? I want to make sure that she has an interlock for now, just for a limited time.
Judge, if I can speak to that briefly,
Sure.
just to reassure the court that she fully understands the court position. I had her research and write an essay on alcohol-related accidents and fatalities. We can turn that in and take a decision-making course. Her case is a stop for expired registration, no accident. You got the blood this morning, it's a 1-3. She has no criminal history. So I would ask the court that to use this, the research she's done in the 28 days without driving at all, to understand that she gets it. And if we can not have the interlock, as would have been if she didn't have an open container, that we proceed further and let us do the work of getting the discovery move forward.
Okay.
I can turn those things.
I want you to know, I will act to your lawyer, but if I find that you're using alcohol, I'm going to blow a gasket. I'm really just going to lose it. Just don't. That's all I'm asking you to do. Do you understand?
Yes.
Okay. So I'll take a look at this. I'm going to acquiesce to you.
Thank you, Judge.
Just don't. Life is too short to spend the next month in a 6x9 box.
Okay, I understand. The report described a court hearing where the judge made decisions about Hawkins's bond conditions, even though her blood alcohol content was above the legal limit. It highlighted how the judge used his discretion and the separate process for administrative license suspension under Texas law.